Okay, so let's begin the session, and Bob Topel has the floor to talk about how legislation cost benefit can be improved.
I just want to start with a comment that I'm struck by how polite all the lawyers are when they are interacting with each other. And in my experience, that seems so out of character because usually I'm on the receiving end of sitting on a witness stand or something and getting questioned. And I was reminded of it when Will accused Michael of trying to get him to agree with something. And one of the rules I've learned over the years is when a lawyer says to you, "Wouldn't you agree, Professor?" that you can stop right there. The answer is no. So I'll probably say some things that you can disagree with here. I liked Peter's talk. It has a lot to do with what I've been asked to do. And you might ask how I ended up doing this kind of stuff. Well, when you reach it, as an economist, I guess when you reach a certain age, you can pretend to be an expert on many things. And Charlie and I first encountered each other when I was asked at a conference that we both go to in Mexico, in Alamos every year, to talk about populism. Well, I had never talked about populism, so I wrote a thing about populism. And Charlie said, "Well, why don't you come to our Rule of Law conference and talk about something else you don't know about?" And so I came. So here I am. Last year, I was asked to be a comment on Deanna Furchtgott-Roth's paper that, in a nutshell, lamented many of the things that Peter talked about, and that is that it was about executive overreach in the expansion of the administrative state. And she had a number of examples that provoked outrage both for her and for me and for everybody else. And her solution was a lot like Peter's, that Congress has to reassert its authority. And my comments could, in a nutshell, were, well, good luck with that, because I didn't see exactly how that was going to happen. So my paper is about the expansion of the administrative state and how it's sort of an equilibrium outcome. It's something that you'd expect from the nature of the mechanism and the preferences of the actors. Now, I don't know. And in a nutshell, they said that they wanted to get rid of 2 regulations for every new one that they brought forth. And to summarize a lot of information that I have on some other slides, and I won't belabor for very long, there's some evidence that the Trump administration has done exactly that the flow of new rules and regulations is dramatically lower than it has been in previous administrations. But those major rules are the tip of the iceberg. Since 1980, we've averaged about 4,000 rules per year coming out of administrative agencies, and I think that's a number that Peter referred to as well. About 20,000 pages per year in the Federal Register. Here's a breakdown. We don't need to belabor this. You can look back at it at some other time, but it just makes the point that Peter was making. Did I go too fast for this? There we go. Okay, so here's some what I regard as basic facts about the regulatory state. And I want to remind you that this is an economist talking about law, so you can correct me on my mistakes as we roll along. The Congress passes a law to deal with a social problem, and this was part of my question to Peter just a few minutes ago. When Congress passes a law to deal with a social problem, in the administrative state that's evolved since the 30s, it empowers an agency to interpret the law and to address the problem. So the examples I give here, and I'll spend a little bit more time on the Civil Rights Act, or the Clean Air Act. The Environmental Protection Agency was charged with dealing with air pollution. Okay, well, what does that mean? The Civil Rights Act of 1964, the Equal Employment Opportunity Commission, so it's an independent agency, was charged with dealing with employment discrimination. Now, remarkably enough, as I'll point out in a minute, when you read the Civil Rights Act of 1964, it defines a whole lot of things. It does not define employment discrimination. That's left to the authority of the agency to figure out what that is, what the span of their control is going to be. So the agencies are agents. with delegated authority, and they're part of the executive branch, as Peter pointed out. And they create rules and regulations. In effect, they become legislative bodies, but they're subject to review by the language of the statute and the courts, by Congress itself, and by the executive branch. But the statutory language, as I just pointed out in the context of the Civil Rights Act, is typically kind of broad, and it's often inevitably so, in my view. And it's that way by design. Not just that a constraint that it had to be that way, but it's that way by design, and that's a key fact. And then we've already talked about Chevron and Seminole Rock that give deference to the opinions of agencies in interpreting the law. So in the context of Chevron, I think the word that was left out in our discussion of it earlier is that it has to be a reasonable interpretation of the statute as judged by the court. So those rules and actions are monitored. So the way I think of the problem is it's a principal agent problem from an economist's perspective. The principal is Congress. Congress delegates authority to an agent to carry out actions on its behalf. But Congress doesn't alone act as the monitor, which is typically done in a principal-agent relationship. There's three layers of monitoring. There's Congress itself, there's the executive branch, and there are the courts. And so the example I give is I'm going to go on. I'm going to skip over the Congressional Review Act. What I'd like to get to is an example of the discrimination under the Civil Rights Act. Also, I use the acronym CRA, of 1964. It outlawed discrimination in employment on the basis of race, color, and other stuff. And it created this new agency, the EEOC, with various powers to enforce the law. There's the delegation of authority. But if you read the law, it defines what a labor union is, what a place of employment is, what hours of work are, but it never says what it means to discriminate. That was left to the EEOC, but that's the very subject of the law. So it's a good example, I think, of this delegation of authority to interpret the span of the law's power or the law's jurisdiction. So that led to an early controversy. Many of you know about this case, Griggs versus Duke Power. And in that case, Duke Power had an employment practice that said in order to reach certain higher positions in the firm, you had to have at least a high school education and you had to take a test. Well, the EEOC came back and came up with a novel interpretation of the law. There was nowhere in the statute that said that creates a disparate impact on a particular group of individuals, here blacks, because they were much less likely in North Carolina to have a high school degree. So it's a race-neutral employment practice. It wasn't explicitly prohibited by the law, but now the boundary of the law shifted. And in Griggs versus Duke Power, the Supreme Court said, yeah, that's consistent with the language of the law, so that particular classes of employment practices that had disparate impact were deemed illegal by that decision. Later on, and this is also a good example of oversight by Congress, later on the Supreme Court weakened that in Antonio and said there could be a business justification rather than a business necessity defense for something that has a disparate impact, after which Congress came back and said in the Civil Rights Act of 1991, I think, that no, we meant business necessity, so they made it more restrictive. So this monitoring by Congress with delegated authority and monitoring by other institutions here, the courts, is kind of exemplified in here. But the boundaries keep marching out. So now, under the Civil Rights Act of 1991, disparate impact has to be a business necessity, and now the EEOC is further pushing the boundaries out so that criminal background checks in hiring are challenged as having a disparate impact on African Americans or Hispanics, because African Americans are more likely to spend time in prison than other groups. So that's an example of the expanding state. So when we think about that, it illustrates these common features. The language of the statute was vague. The statute created an agency. The agency, this is key to what I'm going to talk about, attracts experts. And what we might expect is that those experts, those people who join the agency, have a disproportionate belief in the mission of the agency. They want to find the thing they're looking for. Here it's discrimination, or they want to expand the reach of their power. And the agency's powers include the power to interpret the statute and to create new laws, new regulations, new guidelines, whatever you want to call them, that are constrained by the original statutory language and by oversight. So the agency becomes a legislative body in that sense. So the EEOC succeeded in expanding the domain of its power outside the literal interpretation of the statute. It expanded the meaning of the statute in that sense. So the administrative estate grew outward. So the common features, going on a little bit, the actions of the agency, though, are reviewable by courts, by the executive branch, and by the legislature. And by expanding the boundaries in one instance, it created a new opportunity for expanding the boundaries. And that's the nature of what I'm going to talk about. So here's a theory. I'm an economist, so I had to have a theory. And I'm an economist, so I had to have a model. So you're going to have to bear with me. You can admire the details at your leisure. So it's an agency problem in combination with incomplete contracts. Their statutory language is inevitably incomplete, partly because it just had to be, and partly because Congress meant it to be. And like any economic model, we need to understand some key things. The preferences of the parties. Here are legislators, executives, regulators, and courts. We need to understand incentives, and we need to understand the constraints. And with those, we can say something about behavior and the nature of the equilibrium outcomes. And so the key question for me is going to be when the scope of a problem, of a social problem, isn't fully understood at the time the legislation the legislative branch decides to deal with it, then the boundaries of the regulatory authority actually should expand over time, because they're asking the agencies to figure out what the scope of the problem is. And the agencies have more expertise to deal with that than Congress does, than legislators do. So we expect it to increase over time, and that's not necessarily an inefficient thing. But many feel that the boundaries expand because of biases or an appetite for power by the administrative state itself. So when does this latter phenomenon occur? When does the state grow too much in some efficiency sense? And that's the question I want to try to ask, and I'll also try to ask whether it's also inevitable. And yeah, I think it is kind of inevitable. So like Peter, I won't have an answer to the question of what to do about it. So one of the scariest quotes in all of jurisprudence to me was when Thurgood Marshall said, "Do what you think is right and hope the law catches up." And that's kind of a summary of what the administrative state engages in. So here's my basic fact. I've already mentioned it. The people that are attracted to the agencies have a disproportionate belief in what the agency does. They are missionaries in the sense that Chris DeMuth and I have discussed in the past, and they also have career concerns. They have a strong incentive to find the thing that they're looking for. And so they're going to be constantly pushing up against the boundaries. And that creates selection on views and politics of career professionals, that they want to expand the reach and regulatory power of government. So the EEOC wants to expand discrimination law. The National Labor Relations Board wants to enable union organizing. The EPA finds out that CO2 is actually a pollutant after all, and so on. So the key point here is that the preferences of those who craft the law and those who execute it can be more or less aligned. And that helps us understand how laws are written, and also helps us understand that it's with the knowledge of how the agencies behave below them. So the constraints are the statutory language. What did Congress write in the first place, and why did they write it? Also the preferences of the executive branch leadership, the president and agency heads. So electoral process may create less selection on preferences. You may want to corral the bureaucracy. But that creates predictions for the nature of the laws that are written. by Republicans, for example, versus Democrats. Republicans might be more restrictive in their language and Democrats less if the preferences of the state align with the preferences of the party in power in Congress. And the courts have a long-term impact as a delegated monitor by Congress or by the nature of the Constitution as a monitor and enforcer of rules, so appointments are consequential and controversial. Reviewers of fact then can have their own preferences that may or may not align with the regulators or with Congress. So here's a little model of all this. And this is what the part you can admire at your leisure. But what it comes down to is this. I've set up a model where agencies go out looking for a problem. And they collect information on the nature of the problem. That's my little parameter alpha up there. But it's a noisy signal that they collect. And then they're going to report their information to a monitoring party that I use as, I needed something to call it, so my metaphor is the court. And the agency can bias its private information by reporting something else than what it actually observed. That is, it can exaggerate based on its own preferences. So it's going to report something that it observes plus some parameter beta that reflects its preferences. And the agency's missionary preference, it benefits from claiming a higher observation of the problem than it actually observed. So that's just their bias. It can be strategic or not. It can be that we want to do this because we want to move the law, or just because we always exaggerate. So the court, the monitor, or it could be Congress, the executive branch, also collects information. You can think of this as its prior if you want. And it has unbiased, I'm not going to say it has a biased prior at this point. It has an unbiased prior, and their information, they're going to compare to what the agency reports. And it can sanction the agency, as I'll show you in a minute. But the court combines its information with that that's brought in by the agency, and it decides whether an infraction has or has not occurred. Now that process has some noise, and you can think of that as the ambiguity of the law, in that variance of what the court observes, or you can think of it as the court's prior. How tight is the court's prior on what its opinion is, or you can think of it as simply the noise in what it observes. So, to jump down a little bit, the court's going to solve this problem. It can sanction the agency for being biased, and it knows the bias that the agency is biased on average. So the question comes down to this: can this bias survive in the equilibrium of this apparatus, this model? That is, can the agency continue, in spite of sanctions, can it continue to be biased on average? The answer is yes. Will it be biased in particular instances? Of course it will if it can be biased on average. The better the court's information, the less likely it is the agency is to be biased, because they know they're being watched. And so when the court's has a tight prior on what its opinion actually is, they're going to bias less. When it has a loose prior, they're going to bias more. And then the part of the key is the bottom down here, the welfare of the agency. They like being biased. So in equilibrium, if they get to be biased, they're better off. And so they benefit from their bias. Now, what does that mean? That means that ability to exercise some bias is a recruiting device for the agency. That's how you get the missionaries in there. They want to be able to do this thing, and so long as their ability to do it in a government agency is greater than what they can get elsewhere, you're going to attract missionaries to agencies. So the predictions from this model have come down to this. Monitoring by the court is imperfect, and so bias increases with the agency's preference for bias, the court's sanctioning powers when they are weak, the statutory language is more imprecise, or the court does not have a strong prior about the case. Those are kind of things we might expect. So the court defers more to the agency when language is imprecise, or when this parameter that I have for imprecision is large, and less when its prior is strong. And knowing the degree of the court's deference to its opinion, the agency chooses how much it's going to bias its opinion. When there's more deference, they bias by more. So agency bureaucrats then benefit in equilibrium, and the rest of that is the points I was talking about before. Other implications. Language is never airtight. So there's going to be constant pressure to be pushing the administrative state outward. We'll write statutes recognizing the preferences and incentives, and that the state is going to expand. Now, one of the things that I emphasized in my introduction to my remarks was, well, we kind of expect it to increase over time because we've delegated authority to go out and find the extent of the problem. But can we also have a situation where the biases are affecting outcomes so much that you're expanding by too much? And the answer is yes. And there's the equation that explains that it's yes. And you can admire that at your leisure too. But the point is this: when bias exists, the agency, especially when its opinions on a particular matter are extreme, can move the court's decision out beyond the point where the efficient outcome occurs. So again, now the state is not just expanding because of the structure of the problem, it's expanding because of the preferences of the agencies themselves, the missionary preferences. So I'll hand it over to Price now.
Okay, so last year, Bob described this very briefly. Last year, Bob expressed skepticism when Diana was talking about her desire for Congress to take back power and to rein in the administrative state. So based on this interest group model, which he described that you can admire at your leisure if you like, he talks about what would happen with the various biases that might pop up in these various things. And so Charlie and Mike challenged him to make his case, and so Bob decided to make it with some glorious mathematics. So his goal was to see if common sense stories fit a formal model in which people are maximizing in the way that you might expect. And so the goal of this was to kind of lay out what would happen. And he gets the kind of predictions that you would expect, but he gets it in the context of what economists call, a rational model in these kind of things. And so that's the focus of the paper. And so he gets a bunch of results, and so you can actually skip all the mathematics or whatever, because in the paper, and you can get all the basic points that he's trying to make, and you can be reassured by the mathematics that it all works in the sense of a mathematical model. And so I noticed that when Bob threw up all the Greek letters and things like that everybody except Jesus actually glazed over in the room and stared off into oblivion. And David, who looks like Christian Bale, was thinking about, well, maybe I should be fighting crime as Batman or something like that. Did you know you look like Christian Bale? No? Well, now you do. That is a major, all the women in the room are swooning, so. Okay, so I wanted to point this out to you. I pointed it out when we were there in March as well, the differences between being an economist and a lawyer. So the economists like to confuse everybody by putting up Greek letters and do all sorts of things like that. You usually have to take about 5 years to try to learn what these letters mean, and even then, you don't. Okay, and then
in economist defense, what that actually means is that we think that the things that we say actually have to be true.
Exactly. There you go. Okay, yeah, and so the good side, though, is the lawyers, all they do is throw out case names that you've never seen before. So you've got Chevron, Seminole Rock. I really like the Neo Park Line Rule 23B2, non-mutual offensive collateral estoppel. That was the one that really took me out. So anyway, I just wanted to point this out. It is a lot of fun talking about these things, and they're very nice at dinner explaining what the cases actually are about. They're always fascinating. But a lot of times in the course of quick conversation, that does not happen. Okay, so he's got a principal agent model. He described it quite well. The one thing he really didn't describe it much, and I think is actually really the central point he was trying to make to Diana in last year and also this year, was that he's talking about Congress's incentives itself. And this is very important for the whole discussion. I mean, it's important for Chris's discussion coming up and also for Peter's discussion at lunchtime. He argues that the members of Congress actually have an incentive to actually let the administrative state go on because they're not experts with great knowledge. He made that point at lunchtime. The language that they get is a result of compromise between conflicting interests. And so one of the interesting things to think about is when in 1964, when they come up with the Civil Rights Act, the Kennedy administration could not get this act through Congress. It took the LBJ coming in there and cajoling all these Southern senators and all these Republican senators to vote for this thing. And you're trying to figure out, so what were they thinking about the word discrimination that they would let this thing go through and not be defined? And it'd be interesting to see what's going on in that kind of process. But vague language makes it easier to defend it to their constituents because no one really knows what it is. And so, and it also empowers the agency. But, you think about this, how are they coming up with this? And so basically what he's saying is that the precision of language is driven by these specific incentives and constraints. And Bob and I and a lot of people in the room, I think, are worried about when Congress gets the power to rein things back in, are they really going to rein it back in, or are they just going to turn around and do exactly what they've been doing before and just let it fall apart again? Okay, so he's got agency workers, they're permanent employees, they're specialized in the topic. He's got the monitors, and he's got all these other things. And so this is actually the major thing that Bob did to me when he revised the paper. So I had this picture that was supposed to decode all the various Greek letters for everybody in March, but then he changed the notation on me. So half the notation on this slide no longer works, so that's gone. Okay, so the comparative statics actually do make sense, and that is in a case-specific bias, there's a mean bias that's higher, so that the agency has an incentive to increase their bias when the report has higher impact, when they have more activist tastes, the court sanctions are lower, the court is less confident about its own information when making a decision. The courts are often very worried about the amount of information that they have. And the lower internal agency marginal costs about the importance of the report. Okay, so my comments about this are the following. The narrative seems very asymmetric in the sense that it really emphasizes the agencies going out and doing more things than you expect them to do. Now, Chicago in the 70s, you were at Chicago in the late 70s and stuff, right? For 3 months in the late 70s. So he was there, could see the whole ethic. They were talking about capture by corporations and other kinds of people. I spent most of my career writing about capture in those kind of situations. And so it's kind of asymmetric because he's talking about the rise of the regulatory state in this context, but a lot of times, whatever, it seemed like that the capture was actually limiting the regulatory state. And so you've got and that would be things that the progressives would not like in those contexts. And I think that helps sell the story if you can talk about the symmetry going on both sides, because it seems to flip back and forth depending on how long you've had the presidency, depending on the party. And so I think that that's really important about this. A second thing is career advancement. So he's talking about career advancement being something that's based on being very, very forthcoming. But I have a good friend who was the acting head economist for the FCC, and he said mostly what he spent the whole time doing was 14 hours a day trying to stop the stupidest ideas he had ever heard in his life. And so maybe stopping some of these things is actually a thing that gets you promoted as well. But it's hard to say. One thing that popped up in the paper, didn't pop up in the comments, was something about weighting extreme opinions. And I think that is really important about talking about extreme opinions as to whether or not they're going to get there or not. Because when you think about this, as soon as you have stare decisis in the court decisions, any of those extreme opinions are going to be put in there and they're going to last quite a bit longer. So I have a sense that probably most of the really extreme opinions are going to get struck down in this process. And then the next big step, which is the really toughest part, is actually to model with mathematics the congressional incentives, because that's really where the rubber hits the road in the final analysis. So he's done a really nice job. I mean, a really nice job. This is a very, very simple model. It's very clever, and it actually gets the kind of comparative statics you would expect, and it also reinforces the very ideas that people are talking about in this room. We've talked about it in all those settings. Let's see, I think I have one more. So I just wanted to leave that up there to allow you to see, just admire all the various ways that we try to confuse each other, and also we try to have these conversations. So.
Thanks, Bryce. And before I turn it over to Bob, I want to remark that your point about capture, about 3 years ago, we had commissioned a study that Howard Rosenthal and Sanford Gordon did, looking specifically at how the regulatory agencies were lobbied by the financial services sector over the mortgage standards that were handed to them to decide by Dodd-Frank. And actually, it's a great example of what you're talking about, where the point was that the regulatory agencies definitely moved in a direction away from effectiveness because of the political constraints that were brought to bear on them. So I think that, it's your work, of course, has spent a lot of time on that, but then we've seen even very recent.
Let me say one thing about that. The amazing thing in that study was how little money they had to spend to get this done.
Yeah, exactly. It's sort of like getting professors to do things. It's amazing how little it costs. So let me give Bob a chance to respond before we start questions from the rest of us.
Yeah, thank you. I have no objections to Price's comments. He referred to one of the things, weighting extreme opinions. And I think that's actually really important because one of the things that agencies will be aware of, at least in the way I think about this, is they'll be aware of their reputation. And if they want to have an impact in extreme situations, then if they're noisy all the time, exercising bias all over the place, well, then the monitors know that in the way I think about this problem, and less weight is given to their opinion. So as it turns out, when they're less noisy on average, then their extreme opinions get more weight and move the ball more. Those are the situations where you're more likely to push the boundaries of their authority out beyond that which would normally be efficient. And so then with some, I'll use a word that Price didn't use, he talked about stare decisis or precedent. There's some hysteresis in this process. So once you get out there and there's been a finding that this particular thing is illegal or the boundaries are there, then that tends to stay in place. Then the next goal line is to get beyond that. And I think that's a large part of what we see in the growth of the administrative state.
But before I open it up and start taking more questions, I want to try to link a little bit the discussion that we had with Peter's talk and that we've had in prior sessions with your model. And, I want to echo what Price said, that I think you really have done something that none of us saw coming, which is writing down a coherent, fairly crisp model that allows us to have a conversation about a really wide array of things. So what I want to do then is start that by referencing Peter's prediction. So Peter predicted that Chevron deference could be overturned. So in the context of your model, how do you think about comparative statics for the non-economist means if you change an exogenous variable, like in this case Chevron deference, what effect does that have on the endogenous variables, the outcome variables in the model? And then can we say anything about the welfare economics of that in the context of your model? So you have a parameter, I think, about court sanctioning. I'm not sure if that's the right way to introduce it. I'm not sure if the model is set up in a way that Chevron deference disappearance has a clear analogy, but any ideas?
Yeah, actually it does have a clear analogy in what I did. I had this parameter up there, if you will, which was the weight that you put on the agency's opinion. And that weight, no, that's a different one. So, but this has to do with the ambiguity of Congress's language in creating the statute, which is more or less the room to run within Chevron. And when that room to run within Chevron is reduced, two things I think will happen. One, Congress will create more precise language in response to that. Maybe that comes to Peter's comment about intent. And the other is when you make language more precise, or where there's less room to run, the agency has less room to exert bias. And so the average amount of bias across all these particular cases goes down because they're choosing the amount that they want to bias their opinion, subject to their knowledge that they can get sanctioned by the court. So the sanctioning power of the court is more powerful when there's less room to run, so to speak.
Welfare implications?
You're less likely, in terms of welfare implications, if you think that there's some critical boundary where a violation actually occurs, and the bias, the extreme opinions, the bias of the extreme opinions can push you beyond that boundary. That's the point of inefficiently expanding the welfare state. Then when you make language more precise, you're less likely to go outside that boundary. The court's decisions are more likely to be accurate.
So it sounds like you haven't come out and directly said it, but that there's an argument to be made within the context of your model that the repeal of Chevron deference could be welfare improving.
Well, I don't know exactly what the repeal would mean. More precise language would be welfare improving. I don't know what you do about delegation where you almost inevitably have to delegate authority to interpret a law.
And I'll just say, I think, this paper could have a very large impact, and I think its impact would be greater, maybe, if you use that as a hook.
Okay, thank you. So I fully agree with Price's assessment that this is a very elegant and very crisp model. Something I mentioned back a few months ago was that, and I know this is probably beyond the scope of what you can do here, is thinking a little bit more seriously about the dynamic aspects of the career concern, like, think about an Armstrong type of model of the bureaucrats and the repeated interaction between the agency and the court. So if I'm the director of the agency, I may not want to do a too overly biased report because that's going to lower my continuation value with the court and stuff like that. I don't know if that will give you like two different allocations or not, but it will be nice to understand that a little bit better. And respect to Charlie, and again, this is similar to what was said before. It's not that I necessarily agree with it, but that could be the following argument. Let's imagine that we under-legislate that the Civil Rights Act was not expansionary enough because of any type of legislative bias. Then it can be the case that having a biased agency actually corrects the under-bias by the legislator, and then it's actually not clear what the welfare will be on net. I mean, and, I never say that. That was some other economists on the room.
Okay. Do you have anything you want to say about that?
Yeah, only that dynamics things are hard. And I do refer in there to concerns about their reputation, because in certain situations they may want there may be situations where the agency wants their biased opinion to have a large impact, but if they're noisy all the time, exerting bias all the time, they get a reputation for that, and so the monitoring agency, the monitoring parties, then give less weight to their opinion. So you might want to keep your powder dry in order to move things when they really matter to you. And I think that has some of the flavor of what you're talking about.
This may reflect more my disciplinary unfamiliarity with what you're doing, but I have questions sort of getting at, what's the point of this? And that is, so there are a lot of equations, all of them involving Greek letters. Is it the idea that there are numbers that could be plugged into those Greek letters based upon empirical research such that we would actually be able to, verify, the thesis? So, for example, you hypothesize that the existence of Chevron deference results in Congress legislating in more expansive language, and that cutting back on Chevron deference would result in more precise legislation. That's, I don't have any quarrel with that as a prediction, but is there any prospect that there might be numbers that we would plug into your equations that would either prove or disprove that?
Not explicitly with regard to Chevron deference, but I do refer to one empirical experiment. So allow me to assume that the priorities or preferences of agency bureaucrats, the missionaries, if you will, are more aligned with the preferences of a Democratic Congress than with a Republican Congress. Then you might expect more precision of language as a constraining mechanism out of a Republican Congress than out of a Democratic Congress. Now, since parties turn over, you'd also expect that they're forward-looking, that they know that they're not always going to be there, but the agency is going to be there. But one prediction would be the precision of language that comes out of whichever party you think is more aligned with the preferences of the agencies and bureaucrats themselves. So and then you can do the usual stuff they do these days to try to find precision of language.
Can I just make one point? So I don't know if you'd put specific numbers in, but I think Bob is giving you an idea of, he's got like about 6 or 8 predictions. The predictions themselves actually could be turned somewhat into numerical, like how big is this and how big. So it's the predictions, I think, that you would test, not so much the actual strength, or you wouldn't put the actual numbers in there. You could predict the directions in which you expect things to move and then test for the directions.
David, you're next up.
So I want to make a comment that will start out sounding like a lawyerly debater's point, and so therefore will remind Price of the unpleasantness this morning. Offensive non-mutual collateral estoppel, but will hopefully end up in a useful or at least interesting synthetic place. So here's the debater's point, which is that the EOC doesn't actually have rulemaking authority under Title VII. It doesn't have the ability to promulgate regulations with force of law effect. It does a little bit. It does as to federal employees, but that's a narrow slice of employment discrimination. EOC does have rulemaking authority under the Age Discrimination in Employment Act and under the Americans with Disabilities Act, but again, not under Title VII proper, right, the non-federal employee part of Title VII. Instead, the coercive authority that EOC has had starting in 1972, not even in 1964, as an entirely toothless agency in 1964. In 1972, EOC was given the ability to go into federal court and file a civil action, like you or I could, in particular kinds of cases, pattern and practice cases, and try to convince that court that discrimination had occurred as defined by the court. Why does this matter? I think it connects up to a lot of the things we've been talking about today, because the dream of those who would revive the non-delegation doctrine, so this goes back to Peter's really excellent lunch talk. The dream is that it'll have this upstream disciplining effect on Congress, that Congress will write, better specified, more detailed statutes in response to a revival of a hard-edged version of the non-delegation doctrine. But there are plenty who worry that if you revive the non-delegation doctrine like that, what you'll get is Congress will do the same thing that they always do, which is write vague statutes. Why? Because it serves their credit claiming and blame avoidance purposes. It's like sort of political science 101. And what will happen is you'll push a whole bunch of policymaking to the courts, kind of the way Congress pushed a whole bunch of policymaking under Title VII to the courts starting in 1964 when they created an entirely private AG-based regime, but then again in 1972 when they gave the agency the ability to go in and file a civil action. And we should worry about that then. We should worry about pushing lots of policymaking into the federal courts, and this takes us to another part of this conference, which is the national injunction debate, right? One of our biggest anxieties about national injunctions is pushing a lot of stuff into the federal courts and having them do a lot of federal policymaking. So hopefully that's a reasonable synthetic point and not merely a debater's point.
It's not merely a debater's point, but let me ask a clarifying question. So under the Civil Rights Act, they were empowered to bring actions. They brought an action in Griggs versus Duke Power. It was sanctioned, it was endorsed by the Supreme Court. Now, what's the difference, the practical difference there between issuing a rule that's subject to review and taking an action that's subject to review that pushes out the boundaries of the administrative state? And then, by the way, what subsequently happened, jumping all the way ahead in the Civil Rights Act of 1991, is that Congress did clarify their intent, at least as of 1991, in saying, no, the Supreme Court in Antonio was wrong. We want it to be business necessity. So I kind of fail to see the distinction at a practical level between creating rules, creating guidelines, and bringing actions.
I mean, I think there's an important difference there, which is, when you promulgate a regulation, it's subject to some fairly limited political ventilation through the notice and comment process, and yet that rule is given force of law effect, and in fact ladle on some Chevron deference, and you have some final decision-making authority or close to it. Whereas if the agency can only go into court and press a civil action the same way you or I could, the final decision-making authority rests entirely with the court. And indeed, because the EOC lacks rulemaking authority, it is not entitled to Chevron deference at what's called Chevron Step 0. And so therefore, there's no need to defer to what the agency thinks constitutes discrimination.
So perhaps my discussion of the example was inapt, but it still is the case that when they bring the action, they were able to push the boundaries out beyond the legislative language that Congress had provided to them.
Yeah, that's right, and they appear as amici in cases as well. That's absolutely right. And of course, your paper still works just fine as to the ADA, where there is real rulemaking authority. So that's why it really is, at the end of the day, a debater's point.
See, I think you actually explained why they didn't bother to define discrimination very well in the 64 Act, because LBJ promised that he wouldn't be doing anything along those lines, and it was focused on federal employees and not on individuals. So it was then the expansion occurred when they started doing the things in 71.
You know, okay, go ahead.
This then invites, I think, an empirical investigation question, because you might want to know, does it make any difference? So we have a natural experiment that the EOC has regulatory authority over the ADA and not over Title VII, and then we can run some of Bob's equations and predictions and say, do any of these things make any difference in the real world? And I don't know that it does. Does anybody think that the ADA is actually substantively very different from Title VII as a result of that?
So there's a paper by Maggie Lemos that does at least a back of the envelope version of
What's the last name?
Lemos, Lemos. She's a law professor at Duke, but tries to think about some of the incentives. How the incentives might be different as between agency delegations and what she calls I guess court delegations, right? So and then does some back of the envelope type stuff, comparing the sort of the level of specificity that a court would apply. Someone else, Sean Farhang has another empirical piece. He is a law professor at Berkeley, and he's quite empirically gifted. And he has a paper on the nature of delegations that looks at delegations as between agencies and courts. Anyway, I'll stop there.
I also want to link this discussion to the point Jesus made earlier, because as I was listening to David's comment or question, I was thinking, so if this all gets pushed with non-delegation to the courts, then the biased attractive tendency that you talk about, that is bureaucrats wanting to come to the agencies, well, now they'll want to go to the courts instead, right? And so the point is the parameters in the model will change dynamically.
It's a tougher job to get.
Yeah, and so what's really tricky what's great about writing down these models is it sharpens your thinking. You can start actually having a conversation like this. What's tricky is then you realize that the parameters are not given by God, but can actually themselves change with changes in policy, right? So it's a little tricky. Jennifer has the next.
I wanted two things. One, I wanted to echo something Price said, which is to really think hard about which way the bias goes, because the U.S. is very unlike other countries. In other countries, if you're in the government, you tend to stay there, whereas the U.S. is really distinctive in having a really aggressive revolving door. And my area of expertise is corporate crime and securities fraud, and I think very few people think that the people in the SEC are necessarily biased only in one way. In fact, most of the literature is about the revolving door concern and how that, you're getting a job in the banks. That's who's hiring these guys. You're getting a job as a white-collar defense lawyer working for corporations. So there's a lot of that literature is how the bias goes towards under-regulation. So that's a quick point. The other point is, I think when we talk about vague language, we should be really precise about what we mean. So there's, yes. So there's two forms of vagueness. There's a literature in law and economics on rules versus standards. And a rule is much more precise than a standard. But a standard is not necessarily vague. It's dynamic. It allows us to figure it out, but it's got defining features. So I would say fraud is a standard. It doesn't specify exactly what it is in any given case, but there's an evolving jurisprudence about what that means, And if Congress uses the term fraud, then the court will apply it the same way, whether it's computer fraud, securities fraud, or whatever. So it's a vague term. The court has had to grapple. It's not a rule, the way the French would want, a nice civil rule, but it's got constraints on it. And that's, the agency doesn't have the ability to bias the court in the same way as the SEC's found out. When the SEC goes beyond fraud, the Supreme Court slaps it back so fast its little head has spun. Then there's another kind of vague standard, I would say honest services fraud, where there is no, where the court or the Congress uses a term that doesn't exist anywhere else in the law, and we're trying to figure out what the heck does that mean. And maybe that would give an agency room to run. If I think of the DOJ as an agency, the contrary will be that the court will just say, this thing is so undefined that either I have to say it's unconstitutionally vague, or I'm going to give it the narrowest definition possible, which is what the Supreme Court did in Skilling. It's not an agency ruling, but I'm just saying I think we ought to think about vagueness, go wherever you want, and standards, and those are very different. And also recognize that the agencies isn't coming into the court with facts. I mean, where the court is coming is not the facts of the case. The court is coming on the interpretation of the word. So your model is turning on some bias in fact-finding. But I don't think that's where court oversight is. It's interpretations of words.
Yeah, but that's, I'm going to just spend 2 seconds on that point, because within the context of the way I was thinking about it, the vagueness of the words is what creates that running room, if you will. I want to return to your first point, which I liked about turnover. And yeah, the bias could go the other way if we have career concerns that, you know, I'd like to be employed by Goldman Sachs after I get out of here. And I think that the implication of that is that these incentives are going to vary a lot across agencies. If you've ever had the pleasure of dealing with the EEOC, you'll run into some people who are extremely committed to the mission. And maybe that's less true with the SEC. I've never had to deal with them. So these biases could be different in different contexts in different agencies.
Yeah, that makes a lot of sense. John Wallace.
So I want to make a kind of a comment about all three papers so far today, and it'll apply to Chris's as well. I think about institutions and how they change over time. So I think about institutions largely as rules. And I've come to understand that when we really talk about an institution, we mean an agreed upon rule. Right? It's not just that there's a rule there. There's some process for agreement. And when Peter talked today about legitimacy, the only way I can really make that work is that we have an agreement about how we make rules, which HLA Hart would call a secondary rule. So there's primary rules, there's rules that affect how we relate to one another, and then there's secondary rules, the rules about making rules. And we have a reading of the Constitution that there's a very clear secondary rule about how a rule becomes law, or how a bill becomes law. That's what we teach in elementary school. And all these the papers this morning and now are about how, in fact, difficult it is to actually implement a set of secondary rules. So that the secondary rules are changing when you don't like the decision that Congress gives you or the president makes, so you have a national injunction, or you bring a case by the attorney general. And so I think all this is about the potential changing nature of secondary rules. And David, when he talked about, well, they'll just go to the courts instead of going to the administrative agency or to Congress to do this. That's actually, what do we collectively agree is the legitimate way to make a rule and interpret what it is, right? And societies that have weak secondary rules don't do very well, because there's uncertainty about what the rules are and how they'll work, and then all kinds of things come into play. And I think some of the anxiety over these issues is really about secondary rules. And so in this group, as we think about going, we really want to have a discussion not just about the specifics of the national injunction or state attorney generals, but is our system of secondary rules really changing now? And if it really is changing, how do we want to formulate that going forward? Do we want legitimate rules always to end up in the courts and have the courts decide? So a rule is never a rule until the Supreme Court says it's a rule. Is that, what kind of system do we want to have?
John, I'm going to try to sort of in a Manchurian way here, try to see if I can rephrase it, because I thought it was an interesting comment, but I may not have understood it either. I think the point is that illegitimate rules aren't very desirable, maybe not very effective. And so part of what's in the background of thinking about what kind of rules we like is that they have to also come from a rulemaking process that society views as legitimate. And so then the question is, how do we put that, my question is, how do I have that thought alongside your model? But I don't know if that's where you were headed.
Well, it is, but I think, so we teach in the elementary school how a bill becomes law, right? And we have our checks and balance system, which is the Congress passes a law, the executive signs it and enforces it, and then the court system determines whether the law is legitimate and the enforcement is legitimate. And that's the end of the story. And now what's happening is we're seeing decisions being made. The administrative state and the movement of decisions of making rules into the executive branch is a common theme of everything we've been talking about. Is that legitimate? What's not legitimate in what we teach the elementary school students, but it is legit. Congress did it, right? I mean, the Constitution says Congress will set tariffs, and they don't.
I do have something to say.
And just let me remind you that Peter Wallison started his discussion by saying that the reason one of the reasons that this is a salient issue right now is because there are lots of signs that the legitimacy of the process has fallen out of favor.
I agree. And so but any system, in some sense, I have problem with democracy being just defined as the will of the people. But a system in which we have rules for making rules, and those rules are clear, means that if we follow the rules in making the rules are legitimate in some sense. I think that's really true. So the question now is, and what we've been talking about all day, is that the way we make the rules, the actual rule that comes out, right, the rule that constrains people, what Hart would call the primary rule, is getting really, really murky. Because we can block it in certain ways, and that's the main point about what I want to ask.
I don't know if you meant to say what I thought you said, but I really disagreed with it. You said as long as there's clarity of the process, then the rules are legitimate. I don't think that's true.
No, I thought he said that if you're following the rules to make the rule, then it's
right.
Then it gives it legitimacy.
Well,
I don't think that's true. So I would say that you may not be violating the rule, but at some point people start understanding that, let's just say, suppose that all of a sudden people are waking up to the fact that Woodrow Wilson sold them a bill of goods and they're not happy about it. We may be following the rules, but they finally have woken up to what the rules were and they don't like them. And so you're not necessarily legitimate just because the process arrived at it through a legal sequence of events. You're not viewed as legitimate. That's all I'm saying. Does that make sense?
I think in Peter's example, and now this is my response to John, that it's almost the same as yours, that merely understanding that the rules are made according to the rules doesn't make them legitimate in the eyes of the electorate. And that's what Brexit was about. They can be regulating the shape of a banana according to the rules, but it really pissed people off. And that probably has a lot to do with the Trump's election. It wasn't so much that the rules weren't being followed; it's that the rules were being made within a context of the rules that was distant from the interests of those who voted for Trump.
May I defend John for a moment? I think he was. I may have misunderstood, but I think he was saying that it was just as important, and I think this is what Peter was saying, that the secondary rulemaking process be legitimized in the eyes of the people. Is that fair?
He's saying that just increases the probability it's treated as legitimate. If it's not gone through the process, then that really makes it likely it's
Right.
people are going to see it as illegitimate.
I think that when you say increases the probability, that changes the statement pretty dramatically.
Well, I think that's what he's saying.
Right. Okay, Michael, I think we have one final question.
So I
and then let you
also
respond.
was impressed with John's question and wanted to restate it too, which is, I think it's very, so there are two types of rules. There are the secondary and the primary. When you think about Brexit, Brussels is off there making all kinds of regulations. It's regulating what kind of cheese has to be used on a pizza, that sort of thing. And I think that the Brexiteers did not object to the primary rules. I mean, it wasn't about whether Brussels was getting it right about the cheese on the pizza. It was that the people and the ways, the secondary rules are wrong. And I think this is Peter's point as well, is that legitimacy of government is all about the secondary rules. And the problem in our democracy is that it's not looking so democratic anymore, and that's all about secondary rules.
No taxation without representation.
Yeah. Well, but it does remind me of debates during ratification where, the anti-federalists were saying, look, legitimacy of government depends upon it being close enough to the people that it's a genuinely people-driven process, and people like Hamilton saying, no, actually, that isn't what people care about. What they really care about is being, secure and prosperous, and living in a nation where they benefit from what's going on. So Hamilton is basically all about the primary rules, and the anti-federalists were all about the secondary rules.
I'm going to let John have one more intervention before we let these two fellows wrap up, but briefly.
No, I think what Mike said is really, really important. There are all kinds of rules in my life that I believe are bad rules that I follow because the process of creating the rule was legitimate, and I understand that I'm involved in a society where people do not agree about most of the rules, and nonetheless we need to coordinate. So that that element of coordination is so important that when we say it becomes illegitimate, the illegitimacy could derive because we have bad rules, but it's certain to arise if we aren't clear about the way we've agreed to make the rules. And that's the secondary rule problem. And I think that's really, really important to legitimacy.
Bob, do you have any final comments you want to make?
The only point I want to make is that, over the last couple of sessions here, I've heard repeatedly sort of lamentation about the expansion of the administrative state, and it's a sentiment I share. But in order to understand how that happens, we need to understand the preferences of the actors and the constraints involved before we can make clear statements, because one-off examples don't really prove anything.
It's hard to argue with that one, Bob. Before I adjourn and before we thank Bob, I just want to point out, it looks to me like there's a typo on the times in the program, because we're about to have a 15-minute break. Then we come back at 2:30. But we're not going to add an extra half hour to that final session that I'm aware of. So we're going to just have normal time. So we expect that we'll be done with that session at 3:45. So I think that everything ends a half hour earlier than the end according to this, unless I'm missing something. That is, the fourth paper has the same amount of time as the other three papers. So we'll go from 2:30 to 3:45 on the next session. That's what I'm trying to say. But yes, exactly. But before we break, let's all express our appreciation to Bob.